Good day, ladies and gentlemen, and welcome to your Sports Gambling is Legal, Now What webinar. All lines have been placed on a listen-only mode. If you would like to submit a question at any time during the webinar, you may use the chat box located on the lower left corner of your screen. Simply type your question into the box and click on the send button. If you should require assistance throughout the conference, please press *0 on your telephone keypad to reach a live operator. At this time, it is my pleasure to turn the floor over to your host, Kay Warnock. Ma'am, the floor is yours.
Thank you so much. Again, I'm Kay Warnock. I am the liaison to RELAX, and I'm a policy specialist with the National Conference of State Legislatures. I'm just going to do a few housekeeping matters before we begin. The National Conference of State Legislatures and the State and Local Legal Center are pleased to offer this event. A PDF of the slides, including the speaker bios, is posted on the upper right portion of your webpage here. Feel free to download that as a handout. During the presentation, you may ask questions in the chat box on the lower left corner, and I'll read those questions at the end of the presentation during the Q&A. If you're having technical difficulties, please put those in the chat box, and we will also answer those offline. NCSL will be posting an archive of the webinar, as will the State and Local Legal Center, a few days after this presentation. At the end of the presentation, there's also going to be a live survey. It's very short, but if you could answer that, that'll let us know what you'd like to see in the future. So this is our joint event, the speaker bios, as I said. Just a few things. The views expressed here don't necessarily reflect the views of NCSL or of the members of the State and Local Legal Center. Please keep that in mind. So about NCSL. Since 1975, NCSL has been the champion of state legislatures, and we've helped states remain strong and independent by giving them the tools, information, and resources to craft the best solutions for difficult problems. For example, offering webinars like today. The State and Local Legal Center files amicus briefs before the U.S. Supreme Court on behalf of its members, comprised of the Big Seven national organizations representing the interests of state and local government elected and appointed officials. NCSL is a member of the SLLC, as are the other organizations listed on this slide. Now our speakers. Rick Simpson is a partner with the law firm of Wiley Rein, LLP in the Washington, D.C. office. Rick wrote the State and Local Legal Center amicus brief in Murphy v. National Collegiate Athletic Association. Ethan Wilson is NCSL's Policy Director for Commerce and Financial Services. Thank you for joining us, Rick.
Great. Thank you for the introduction, and it's really a pleasure to talk about what I think is a very important and significant case for state governments. It'll be a state and local government entities that will be an important precedent going forward. Today, what we're going to do initially is I'll cover the background of the matter, going through what the Professional and Amateur Sports Protection Act, PASPA, is, giving some background on the New Jersey legislation and the resulting legal challenges that led to the Supreme Court decision, talking a little bit about the amicus brief that my colleagues and I prepared for the State and Local Legal Center, and then the Supreme Court decision, which, as we'll discuss, is really quite a clear, direct, and powerful statement. Ethan will then talk about state actions that various states have taken regarding sport betting already in the aftermath of the Murphy decision, and then we'll come back and towards the end I'll talk about other potential implications of the decision, other areas in which we might see Murphy being applied in efforts to further the interests of state and local governments and their power vis-a-vis the federal government. So first, I want to begin talking about what exactly PASPA is. The statute is up on the screen now. As you see, it basically has two prongs. The first, which is what was the primary topic of litigation that in the Supreme Court and in all the cases leading to it, prohibits a governmental entity, which is defined to include a state and political subdivisions, from sponsoring, operating, advertising, promoting, licensing, or authorizing, down to the end, basically betting or gambling on sports activities, amateur or professional. The second prong, which as we'll discuss later, comes up in the context of whether it can be severed from the first, prohibits individuals, it acts on private persons, and prohibits likewise operating, advertising, or promoting sports gambling or betting, but only where it's done pursuant to the law or compact of a governmental entity. So again, it acts on private individuals, but only in the context of activity, gambling activity that has been authorized by a governmental entity. So we come to the first, and I should mention that the law was passed in 1992, and it was in the context of concern by Congress about what then appeared to be an expansion of sports betting. At the time, sports betting was legal in Nevada and highly regulated in Nevada. 3 states had lotteries that turned on sporting events, state-sponsored lotteries, and those were essentially grandfathered in PASPA. And then interestingly, PASPA gave New Jersey 1 year in which it could authorize sports betting in a highly regulated context in Atlantic City, but New Jersey chose not to take advantage of that 1 year window. And so after that, New Jersey and all of the other states except Nevada and the 3 that had lotteries were subject to PASPA's prohibition. In 2012, New Jersey passed the Sports Wagering Act that legalized and regulated sports gambling in privately owned casinos and racetracks in New Jersey. PASPA gave both the Attorney General and various sports leagues, including the NCAA and the NFL and the major sports leagues, the right to sue to enforce PASPA. Here, 5 sports leagues, including the NCAA, sued Governor Christie and other state officials seeking to prohibit this New Jersey law from going into effect. Christie won, is how we refer to this first case, and the case was known as the Christie case all the way until after a briefing and argument were complete in the Supreme Court, and then Governor Murphy became the governor, and hence his name is on the final Supreme Court decision. But basically, the leagues argued that this law authorizing sports betting on its face violated the prohibition in PASPA against states authorizing state sports betting. New Jersey defended basically on the ground that the law violated the anti-commandeering doctrine and also the equal sovereignty principle. Anti-commandeering we'll get into a bit more as we go along, but the basic concept is that Congress can't direct state governments and state officials as to how to conduct themselves. The equal sovereignty principle, which did not continue to be litigated all the way through in a principal way, had to do with the notion that Nevada was being, and those other states were being treated than New Jersey and the rest of the states that were not grandfathered in. The district court agreed with the leagues and enjoined New Jersey from going forward with implementing the statute. On appeal, the Third Circuit affirmed, holding that PASPA did not commandeer the states. The key point, I think, in this first decision by the Third Circuit was the distinction between authorizing an event and as the court emphasized that PASPA did not prohibit a repeal of the regulations or laws that were in place in 1992 banning sports gambling, and therefore they didn't see how having no law in place governing sports wagering is the same as authorizing by law, and pretty clearly indicated that New Jersey would be free to repeal its prohibitions on sports betting. It simply couldn't affirmatively authorize it. And it affirmed on that basis. New Jersey applied for cert to the Supreme Court, which was denied. So going forward, in 2014, New Jersey effectively took the Third Circuit at its word and passed a partial repeal of its laws that prohibited sports betting. What this partial repeal effectively did was to channel legal sports betting to Atlantic City and to certain racetrack locations which were already subject to extensive state regulation. So the practical effect of it was to allow sports betting in certain locations subject to regulation, but it took the form of simply repealing aspects of New Jersey law that had prohibited that previously. The leagues again challenged the law, and once again the district court held that the law enjoined the governor from going forward, finding that the law was contrary to PASPA, and finding that the PASPA rejecting the state's challenge to the ability of the court to enforce PASPA, the constitutionality of PASPA. The case once again went up to the Third Circuit, and again the Third Circuit affirmed, this time holding that a partial repeal such as that New Jersey did here could amount to an authorization. As the slide indicates, the court held that a state's decision to selectively remove a prohibition on sports wagering in a manner that permissively channels wagering activity to particular locations or operators is, in essence, authorization under PASPA. It's really a kind of common sense argument if you think about it. It's simply saying that if an activity is prohibited and you partially repeal the prohibition in such a way that it becomes allowed, you are thereby authorizing the activity. That was the theory by which the Third Circuit held that the New Jersey partial repeal violated PASPA. And then it held that that law didn't contravene the anti-commandeering principle because it didn't command the states to take affirmative actions. And so it effectively distinguished between a law that would tell a state you must enact a statute requiring X from a law that basically froze in place regulation as it was and that did not command the state to take any particular affirmative action. I think it's worth mentioning before we get into the amicus curiae brief that we filed. The Third Circuit struggled, and it was apparent in the briefing in Supreme Court there's a bit of a struggle to define exactly what PASPA would allow a state to do in terms of a repeal or other change in its regulation. The Third Circuit held in essence that there could be, at least in dicta, it indicated that there could be acts that a state could take, such as a very limited repeal that would allow social gambling among friends and family for small amounts that might pass muster, but it never did define in any clear or precise way what it was that PASPA would permit a state to do. So this time, once again, New Jersey applied for cert, and this time the court took the case. And we, on behalf of the State and Local Legal Center and several of the participating organizations, filed an amicus brief supporting New Jersey. In that brief, we made two primary arguments. The first is that PASPA violates the 10th Amendment because it prevents New Jersey from modifying or repealing existing state restrictions without creating any federal regime for the regulation of sports wagering. Now, stepping back, we didn't question, and really no one questioned at any point along the way, that the federal government could regulate and, in fact, could prohibit state sports betting, sports wagering, if it chose to do so. There's no question that Congress could pass a law directed at private activity and prohibiting sports betting. The problem here is that that's not what it did, and instead what it did was to prohibit states from authorizing sports betting so that the statute was acting directly on the states as opposed to acting on private individuals. We made the point in the brief that really PASPA gave states no ability to make any meaningful changes in their laws as they existed in 1992. At that point, other than the 4 states that I mentioned, the Nevada gambling and the 3 with lotteries, all states prohibited sports betting. Once you look at the holdings of Christie 1 and then Christie 2, whereby states are prohibited from authorizing gambling, and a repeal is considered to be an authorization, it really doesn't leave any activity for state activity, for state decisions as to whether or not to permit sports betting and on what terms. And one of the points we emphasized in the brief is that the states were left with really no meaningful options or alternatives. Third Circuit had held out the possibility of that a total repeal of all regulation of sports betting might pass muster. It's a little hard to see how that could be if the theory is that a repeal by implication is an authorization. It's hard to see why a complete repeal would not be an authorization. But we pointed out in the brief that that is not a meaningful or realistic alternative for the state because no one really contended or would contend that sports betting should be allowed with no restrictions whatsoever. If all regulations were repealed, then you wouldn't have a requirement that people be 21 or 18 years old to participate. You wouldn't have requirements designed to assure that games were that the wagering was conducted honestly. You wouldn't be able to have regulations as to times and places, and so really that was not a realistic alternative. It was an alternative or not. And then on the flip side, assuming that, as the Third Circuit had suggested, it might be permissible for a state to do something like allow a very limited partial repeal that would allow members of a family to bet in small dollar amounts on sports betting. We pointed out that that's really trivial. It's sort of the example we used. It would be like allowing a state to say only that a 19-year-old at an event with his or her family can have a glass of wine. It wasn't that's not where the meat is. That's not where the real decisions would be made. And those were points that we emphasized in the brief. The second point we made, and we also kind of pointed to the purposes of this anti-commandeering doctrine and how they were affected here, one of which is political accountability and the notion that the government officials who make decisions regarding gambling or any other activity need to be accountable, and citizens ought to be able to look to those officials to answer for their decisions. And here, the federal government, in effect, was circumventing that by requiring states to be the entities that were prohibiting gambling, but giving state officials no ability to make decisions or to change what those regulations were. The other point that we emphasized in the amicus curiae brief was that upholding the constitutionality of PASPA could have implications in a lot of other areas. Those we discussed in the brief are noted here: regulation of narcotics, physician-assisted death for the terminally ill, drug misuse and substance abuse during pregnancy, self-driving cars and driverless cars, self-driving and driverless cars. And the point we made there was that what PASPA did and what laws like PASPA, if allowed, can do would be to freeze in place state and local regulation of a wide range of activities, and we kind of use these examples to spin out that concept. Okay, then we come to the Supreme Court decision. I would say it was really outstanding briefing on both sides, a number of good amicus briefs. The oral argument was a really interesting one with two excellent advocates. Ted Olson argued for the state and Paul Clement for the leagues. I think from the argument we were cautiously optimistic that the decision would come out in favor of New Jersey, and in fact it did. Justice Alito delivered the majority opinion, joined by Roberts, Kennedy, Thomas, Kagan, and Gorsuch, and then by Justice Breyer in part. So you've got 6 justices joining in full. And I will say, to me at least, it seemed like an unusually forceful, clear, and an unambiguous opinion. It really is a significant statement with respect to state and local government power. Basically, Justice Alito's opinion, the center point of it is that PASPA's provision on its face unequivocally dictates what a state legislature may do and may not do. And that was, I think, the key analysis in that opinion. And then he also held that provision was not severable from the provision, the Part 2 that I talked about earlier, that prohibits private conduct, but does so only where that private conduct is authorized or pursuant to law. So these are some of the more, I thought, pertinent and forceful statements in the opinion. The PASPA provision prohibiting state authorization of sports gambling is not a preemption provision because there is no way in which the provision can be understood as a regulation of private actors. What Justice Alito is focusing on there is, again, this notion, certainly the federal government could prohibit sports betting, but there's no way to read this statute, Part 1, in any event, as doing anything other than telling states what they could and could not do. Second quote here is exactly that point about the states can do what they want. And I thought this third point was an effective one and directly contrary to what the Third Circuit had held, noting that the distinction between compelling a state to enact legislation and prohibiting a state from enacting new laws is an empty one. Basically, the principle is that the Congress cannot tell states what to do or what not to do in terms of enacting legislation, and Justice Alito, in fact, noted that it was as though Congress had a federal official in state legislatures there to monitor and prohibit certain votes and certain actions, and that just wasn't acceptable. With respect to severability, that Part 2, Justice Alito held in substance that it was not severable that it couldn't survive without the Part 1, and in essence did the kind of traditional severability analysis, holding that it was clear that Congress would not have enacted Part 2 without Part 1, and that it really wouldn't make any sense to enact a statute that would say sports betting is okay as long as it's purely private, but if it's authorized by a state, it's not. That's the point on which Justice Breyer disagreed and took a different position. And then there were the two dissenting opinions that really didn't defend the constitutionality of Part 1 of the statute, but argued that Part 2 could survive on its own. Okay, then with that background, we'll turn it over to Ethan to talk a little bit about what states have been doing since Murphy.
Thank you, Rick. And as you pointed out so well, the legal and the procedural history of this case truly is fascinating and unique. So thank you for sharing that. And thank you, listeners, for tuning in to our NCSL and State and Local Legal Center webinar today. Again, my name is Ethan Wilson, and I am NCSL's Policy Director for Commerce and Financial Services. So I'd like to take this opportunity to discuss where we were, where we are, and where we're headed in this policy space. For the sake of time, I'm going to keep this pretty quick and simple. However, anyone can certainly follow up with me after the webinar. My contact information will be displayed towards the end of this slide deck. To give a little context here, I'm going to quickly discuss what the sports betting landscape looked like for the past 26 years, which is, of course, the time between Congress passing the Professional and Amateur Sports Protection Act in 1992 and where we were up until just a few weeks ago when the Murphy case came down. Technically, and as Rick alluded to, there were a few states that fell under PASPA's grandfathering language. First and foremost, we think of Nevada and its robust system of sports betting. In Nevada, you can place single game bets, parlay or multi-game bets, in-game bets, and other proposition or prop bets. You can bet on both professional and collegiate sports. You can bet on football, baseball, basketball, golf, racing, you name it. Also under PASPA, however, Delaware was also able to offer a kind of sports betting. It's in statute termed as a sports lottery. And you can kind of think of it as sports betting light. In Delaware prior to Murphy, you could only place wagers on the outcomes of multiple games, otherwise known as a parlay bet. And even at that, you could only place bets on NFL games. And basically, that was the sports betting landscape for nearly the past 3 decades. However, enter today and the post-Murphy world that we entered on May 14th of this year. And I'll start with just a bit of context as to how the Murphy ruling affected states. First, it's not like all of a sudden we entered the wild, wild west of sports betting. Sports betting was not instantly legalized across the nation with the fall of the PASPA regulatory regime. As Rick discussed, all PASPA really did was to say, as the federal government, they said, hey, you state legislators, you have prohibitions on sports betting codified in state law, prohibitions that you duly legislated and passed, but now you cannot touch them, you cannot repeal them, you cannot amend them. Basically, the state prohibitions on sports betting were put into a time capsule as of 1992, not to be opened until, well, May of 2018, as it turns out. Although, as we saw, that did not stop New Jersey from trying, and trying they did. Of note, in 2009, Delaware also tried to expand their sports betting offerings, but they were denied by the courts from doing so, and I will talk more about that in just a little bit. So with the court's decision in Murphy and the Professional and Amateur Sports Protection Act ruled unconstitutional, states are just now able to open those statutory time capsules, so to speak, in order to change, amend, alter, or remove their existing bans on sports betting. Thus, post-Murphy, we did not enter the wild, wild west of sports betting because, by and large, the status quo remains intact, and it will remain until states act legislatively to amend the prohibitions that are currently on the books. And so that brings me to the next slide here, state activity both pre and post Murphy. And I say pre-Murphy because, as we will see, a number of states passed legislation prior to the court's ruling, with the caveat of if Congress repeals PASPA, or if the court alters the scope or nature of PASPA, then these preemptive statutes would sort of take effect and allow the states to hit the ground running in a post-PASPA world. And that is kind of where we're at right now with some states. And I'll give just a quick summary of recent state legislative action in this space. At least 6 states have passed some kind of legislation to effectively allow for sports betting at some points in the future. Although, as we will see, there is major legislative and procedural differences in how states have gone about legalizing or expanding sports betting activities. And these states are Delaware, Mississippi, New Jersey, New York, Pennsylvania, and West Virginia. And of note, and contrary to some recent reports and news articles that you may have seen or read, I'm not including Connecticut in this group of states that have legislated to legalize sports betting, because despite a gaming expansion bill that was signed into law in 2017 in Connecticut, state regulators and lawmakers in the state really seem to agree that further action is needed legislatively to legalize sports betting. So that's why I have not included Connecticut in sort of this group of states that have acted legislatively to expand sports betting. And in addition to the legislation already signed into law, there was at least 19 states that introduced legislation relating to sports betting in 2018. But the spectrum of what this legislation would allow or legalize is quite wide, ranging from full, robust legalization to frameworks containing much narrower parameters. And in the 19 states, there have been at least 62 separate pieces of legislation active in 2018. But with that said, the actual number is probably even a little bit higher than that, probably higher than 62. And that just kind of depends on how you classify the legislation. For example, a number of states had legislation introduced to simply study and not actually legalize sports betting. And that trend will continue, and that will only increase for 2019. So that's all great information and just sort of a short little summary of what's been going on. But what's actually been done and who has done what? I'm going to touch on the recent and current state of play in sports betting in the states that have actually passed legislation. Again, that's Delaware, Mississippi, New Jersey, New York, Pennsylvania, and West Virginia. And I start with New Jersey because, well, they deserve it. They fought long and hard to legalize sports betting, and now it's able to do so. For better or for worse, they were the first ones through the door, if you will. They had to buck the legal headwinds and shoulder the costs, the very heavy costs, in doing this. And of course, the legal saga that is Murphy versus NCAA, or rather Christie at one point in time versus NCAA, all started with the state of New Jersey. And Rick discussed, due to the legal posture of this case over the past 6 years or so, and in particular, Christie 1, New Jersey was not able to affirmatively legislate a regulatory framework for sports betting. During Christie 1, the Third Circuit Court of Appeals told New Jersey that it could not affirmatively authorize, but legislate and legalize sports betting. So what did New Jersey do? Well, they tried to follow the directions of the Third Circuit, and instead of legislating affirmatively, they legislated passively. They strategically removed the existing ban on sports betting instead of adding new statutory language. And again, this was in order to abide by the Third Circuit's ruling in Christie 1. But as we know, that still didn't work out on the case's next appearance before the Third Circuit, otherwise known as Christie 2. And this is why, when the Murphy opinion came down, New Jersey didn't have a robust regulatory framework on the books. All it had was sort of a legislative shell. It was a shadow or a loophole, if you will. And of course, this was due to the Third Circuit's ruling in Christie 1 that basically served to muddy the waters once the Supreme Court case came down with the Murphy opinion. However, there's recent New Jersey legislation to remedy this. New Jersey Assembly Bill 4111, titled the Collegiate Sports or Athletic Event Wagers, It passed the legislature last Thursday, so less than a week ago, and actually was just signed by Governor Murphy yesterday. Thus, with the legislation having just become law yesterday, there's definitely still some baking left to do before sports betting really gets off the ground in New Jersey. Although some believe that the first sports bets could take place by the end of this week, Monmouth, I believe, will probably be accepting its first bets perhaps this week. Next, I just want to talk somewhat briefly about Delaware. Delaware is an interesting case. It's been in the news quite a bit recently. And as I briefly mentioned before, Delaware tried to expand its legal sports betting activities back in 2009, actually. So you might wonder, well, why didn't they go through the same problem that New Jersey did? Well, the expanded activity was challenged by the leagues, and it was enjoined, and Delaware did not ultimately expand its sports betting activities. But the statute was never technically removed or repealed. So when Murphy was decided, Delaware's existing statutory framework was deemed by the Attorney General to allow expanded sports betting activity. And specifically it said, and I have here on the slide, the Delaware Department of Finance, in consultation with the Attorney General's office, has determined that there are no legal obstacles to moving forward with full-scale sports betting in Delaware, including head-to-head betting, which permits single-game wagering. Under state law passed in 2009, Delaware may authorize betting on professional and collegiate sports with the exception of games involving Delaware-based teams. So the existing statutory language paired with Delaware's existing sports betting infrastructure resulted in a very swift transition to expanded sports betting. And actually, as we saw last Tuesday, the governor of Delaware, John Carney, placed the state's first bet on expanded sports betting. So as of right now, Delaware is offering expanded single-game sports betting, very similar to what Nevada's been able to offer for decades. I will talk briefly about a couple other states here. Again, New York is a very interesting example of a state taking legislative action to expand sports betting prior to Murphy. In particular, New York's Racing, Parimutuel Wagering, and Breeding Law, Section 1367, was passed in 2013, and it has a provision that reads, "No gaming facility may conduct sports wagering until such time as there has been a change in federal law authorizing such, or upon a ruling of a court of competent jurisdiction that such activity is lawful." Well, enter 2018, sure enough, that did happen. The law is narrow in scope and actually only applies to sports betting in person at New York's 4 casino establishments, and that's in the Catskills, in Albany area, Finger Lakes, and in the Southern Tier. But regardless, because of this law, the State Gaming Commission did indicate last month that it is in the process of developing regulations for sports betting at these particular locations. However, there is still much debate in New York as to expanding sports betting, both in brick and mortar locations, including racetracks, as well as via mobile betting, as well as questions on tax rates and integrity fees and other regulatory parameters. But ultimately, in New York, the policy is certainly far from set, and it will continue to evolve moving forward. Transitioning from New York to its neighbor to the west, Pennsylvania, in October of last year, Pennsylvania also preemptively legislated to legalize sports betting. And again, with the caveat, like New York, that the federal law must first change to allow state legalization of sports betting. And that's designed to prevent or stem any type of potential legal challenges or litigation that might get the state wrapped up in. The legislation in Pennsylvania was codified in Section 13C11 and is titled Authorizing to Conduct Sports Wagering. The law permits any of the state's 12 casinos and racinos to apply for a sports wagering certificate. Moreover, the law establishes a state tax of 34% and a local option of another 2%. And casino businesses looking to expand their gaming offerings to include sports betting would also pay a $10 million licensing fee. Moving on to just the last couple of states here, like some of the other states that have recently acted to legalize sports betting, specifically New Jersey, Pennsylvania, West Virginia, Mississippi has a long-standing reputation for gaming, having numerous casino establishments within the state. In fact, Mississippi Gulf region is the nation's third largest casino market, and Mississippi has nearly 30 casinos currently operating. I think it's 28 to be specific. Thus, it's not surprising that Mississippi moved to expand gaming activities and legalize sports betting. However, there was and has been some controversy around the issue in Mississippi. Like other states, the legislative path towards legalized sports betting in Mississippi has not been all that straightforward. The bill that opened the door for legalized sports betting in Mississippi, on its face, had nothing to do with sports betting, per se. Rather, the legislation called the Fantasy Contests Act instituted a technical change to existing Mississippi law that seems to have incidentally opened the door to allow legalized sports betting, sort of an after effect of the original legislation. According to Mississippi Gaming Commission Deputy Director Jay McDaniel, in an interview with Legal Sports Report published back in March this year, the Fantasy Contests Act removed a provision in Mississippi's Gaming Control Act that required contests to actually take place on the casino premises in order to be wagered on, i.e. think of boxing or something. So with that language removed, and because the Mississippi Gaming Control Act allows for any type of wagering as long as it's done at the casino, on the casino floor, sports betting could technically be legal if the Mississippi Gaming Control Board actually grants permission to casino establishments to offer the activity. So ultimately, in Mississippi, legal sports betting is not currently happening, but with the appropriate regulatory action, it could be offered in the near future without future legislative action. And finally, and last but certainly not least, I will talk just briefly about West Virginia. In March of this year, Virginia passed its Sports Lottery Wagering Act. In particular, the law permits the state's 5 gaming facilities to offer sports betting under the Lottery Commission's oversight. And pursuant to the West Virginia law, the gaming facilities must pay a $100,000 licensing fee, and the legislation set a tax rate of 10%. Of note, there has been some recent dialogue between the sports leagues and West Virginia's Governor, Jim Justice, to potentially reevaluate certain parts of the law, including the possibility of including an integrity fee paid to the leagues. Now, integrity fees have certainly been a hot topic, and while that is a conversation for another day, we could probably have a whole webinar on that issue. It has been an issue in other states, and it's been a controversial issue between industry and sports leagues and state legislatures and state regulators, and it's just something certainly worth keeping an eye on moving forward. So that's really the summary that I have for you guys today on what states have done in this space. Again, expect the trend of legislation regarding sports betting to spike or just to continue moving forward and increase in 2019 and probably years beyond that. And with that, I will hand it back over to Rick to discuss some of the broader implications of the Murphy versus NCAA case. And again, my contact information will be displayed at the end of the slide deck, so please do not hesitate to reach out.
Thanks, Ethan. Not surprisingly, probably, there's been just a ton of discussion and analysis and debate about what the implications are of the Murphy decision. It's become a really hot topic on law professor blogs and in other academic and non-academic circles. Some of the areas in which there has been discussion and debate both ways as to whether Murphy creates a problem as to the viability of existing federal laws includes those relating to sanctuary cities, federal restrictions on state tax laws, FCC mandates, Federal Communication Commission mandates regarding infrastructure, federal ban on state benefits for aliens, and then the potential of future attempts by Congress to prohibit state legalization of marijuana use. And there are others as well, but these are some of the topics on which we've seen the most discussion and debate. One that probably has gotten the most attention that I want to talk about a little bit more is the sanctuary cities issue, since that is such a hot topic these days, and also is, even before Murphy, was the subject of ongoing litigation in several different courts. One of the issues in debate on in those cases has to do with Section 1373A that is quoted here on the slide, which basically says that no state or local government may restrict either a governmental entity or an official from sending to or receiving information from the Immigration Naturalization Service regarding the citizenship or immigration status of any individual. And so if you look at the phraseology of that, it doesn't say states and local governments must cooperate with INS regarding its enforcement of federal law, but it effectively gets part of the way there by prohibiting state and local governments from prohibiting their officials, their employees, from cooperating. On I guess last week, on June 6th of 2018, a district court in Pennsylvania held that this provision and some regulations or orders from the Justice Department implementing it regarding federal funds the provision could not stand consistent with Murphy. And as you can see, the analysis here is that Section 1373A, by its terms, prohibits federal, state, local government entities and officials from engaging in certain activities, and therefore is parallel to the PASPA provisions. That proposition, as I said, has been debated back and forth. On one hand, you have the argument that Section 1373 does act directly on state and local officials and prohibits them from engaging in certain activity. On the other hand, the argument's been made that this really is simply, it's acting on individuals, not on state and local governments, and that it's a reasonable part of the federal government's immigration enforcement efforts, and that in effect all it does is to say that the state cannot prohibit something that federal law here allows. On the face of the statute, and on just this narrow issue, I do think that the state and local governments have the benefit of it, better side of the argument. I think if you look at Justice Alito's opinion, the key question is whether the federal statute at issue acts on private individuals, and he does emphasize that in all of these you don't look at form. It should not be determinative whether the statute says no individual may or says no state may. You look at the substance. The issue is, does it act on individuals, and if so, it can in many contexts apply equally to state actors, or is it something that's in effect telling states what they must legislate, or telling states they need to have their officials enforce federal law? And I think there's a good argument here that on its face the statute really focuses right in on state and local officials, and so falls in the rationale of Murphy. But there are good arguments on both sides, and it will be interesting to see how that turns out. And then likewise, as I mentioned, in several other areas, there is a lot of discussion and debate, and could likely be some litigation about how Murphy applies. You'll see there is an appendix to the slides presentation here that's available to download, and in that appendix we tried to include just some examples from these other fields that I mentioned of statutes that and regulations that at least some folks have argued cannot stand in light of Murphy, and then there's been debate both ways. So with that, I think we can turn it over for questions. As you see, Ethan's contact information is there. I'm also happy to take email questions afterwards. My email information is at the Wiley Rein website, but we'll turn it back to the moderator for questions.
Thank you, Rick. So we have a couple of questions. I'm going to start with one. A number of commentators have noted that the Supreme Court agreed to hear Virginia Uranium v. Warren shortly after deciding Murphy. Commentators have speculated that these two cases might indicate the Supreme Court is taking a renewed interest in preemption. What do you think?
You know, certainly the Virginia case on uranium mining that was taken is a very significant case, and there had not been, I think, a significant preemption case in quite some time. And so it's interesting to see it, and certainly when you combine it with Murphy, it does reflect an interest in these topics. I think we'll have to wait and see going forward. But I think, you know, the notion of preemption and federalism and the relationship between state and federal governments, it's been an important topic since the Constitution came into being, the days of Alexander Hamilton and his comrades. And so I think there'll continue to be significant cases from time to time. Whether we see a spate of them now, I don't know, but certainly this Virginia case is an important one.
Thank you. So here's another question. Do you think most states will allow sports gambling, which allow sports gambling, will put it under their lotteries, casinos, or some combo of both?
You know, I would say it will certainly be some combo of both. I mean, you look at Delaware, and that's really kind of how they house their sports betting activities, that it's sort of termed as a lottery. So it will be some sort of combo of both, but I think most states will probably have a mixture of in-person betting at sort of establishments that you would think of, like casinos or racetracks. But then the other part of that is states that allow, and I think states that do legalize sports betting will do this, and that is allow for mobile betting. It's yet to be seen yet, but I think that most states that do allow sports betting at some point in time will probably also sort of open that up to a mobile type sports betting, whether that's from a handheld device or whatever. In general, that's probably going to be geo-fenced within a particular state, sourcing, you know, an IP address or whatever. But I think to answer that question, yes, it will be a combo of both, but I think that for the most part, the conversation is really going to lie between how much betting is going to be allowed to be mobile versus in-person.
Thank you. Here's another one. Is there a concern that the Wire Act will interfere with state legalization of sports betting via the internet or mobile device in a similar fashion that has impacted iPoker implementation?
Yeah, I mean, that is a fantastic question. I think the answer to that is yes. I mean, I think as mobile betting gets more, as it becomes more accepted and states sort of adopt it as a medium through which to participate in sports betting, it could be an issue, and it's going to be an issue if we start to see, you know, operators operate in more than one state. I mean, as long as it's intra-state, we've seen Nevada offer mobile sports betting for quite a while now, and it's all been geo-fenced within the state of Nevada, and it hasn't really presented an issue. But as more and more states start to adopt this, and you start having neighboring states adopting legalized sports betting, and then you start having businesses operating within neighboring states, yes, I mean, it very well could potentially be an issue for mobile betting moving forward.
Thank you. All right, here's another one. What implications does sports betting have on other industries like horse racing and travel and hospitality?
This is simply speculation on my part, but I think that, you know, for at least to begin with, I mean, it's a novel practice. I think, at least legally, I think that it will have some type of a benefit for in-person establishments or casinos or racetracks or whatever. I think it'll probably work to boost foot traffic in those particular locations. Whether that will be sustained or not, it will, you know, is yet to be seen. As again, it is, you know, this is a novel legal practice. But yeah, I mean, there will be certainly implications, and I think for the most part, it should increase foot traffic in those locations, and I think the goal for states is also to be able to draw some revenue out of that as well. Right,
and in fact, I mean, a large part of the rationale for New Jersey's efforts beginning in 2012 and continuing all the way through the Supreme Court decision in attempting to obtain the ability to allow sports betting was concerned about the state of Atlantic City and trying to revive the commerce there. And so I think certainly one of the goals was to generate additional activity for these kinds of facilities.
Thank you. Okay, so we have one more question, and that is, does the Murphy decision impact fantasy sports regulation?
This is Rick. I don't think so. Only in the sense that that states and local governments are in a position to make whatever policy decisions they want to make in terms of regulation. They have it's part of the field in which they're now free to make decisions and choices. I would think.
Yeah, I think that's exactly correct. And what I would add to that is really what DFS, Daily Fantasy Sports Operators, lobbied for the past few years, which was distinguishing daily fantasy sports as a game of skill as opposed to a game of chance. The Murphy decision does affect that, because ultimately that distinguishing the two practices or the activities, really that's kind of moot at this point. Sports betting is legal, or in states that will move to legalize sports betting, the distinction between having a game of skill versus a game of chance in those particular states that do legalize sports betting, I don't really know what the implications will be in the long run, but I think that distinguishing those activities is moot at this point.
Yeah, that sounds right to me. That's a good point, Ethan.
Wonderful, thank you. So with that, we have taken all of our questions. Rick and Ethan, thank you so much for your time and your information. NCSL and SLLC will be offering another webinar coming up, and I'm going to jump to that real quick here. So, and as I go, I'm going to go through this appendix very quickly so you can see these other topic areas that Rick mentioned earlier, just so that you can see them. So please do download those if you're interested. And here's the upcoming webinar on partisanship and redistricting, what the court has to say. That's coming up on July the 18th, and that's at 1 p.m. Eastern Time. Oh, and guess what, guys? One more question just came through, and I would like to go ahead and ask that of you if you're willing. The question is, I read that sports betting in Nevada accounted for only 2% of the state's overall gambling revenue last year. Considering that, is the concern that if a state doesn't offer sports betting, money will go elsewhere to neighboring states that do offer sports betting a real concern?
Well, what I would say to that is it depends on a lot of things, and it depends in large part on geography and the geographics of where a state is situated in relation to its neighbors and whether its neighbors have legalized sports betting. You look at the I-95 corridor from D.C. basically up to Boston, and all the states that that interstate runs through in a relatively short period of time, it's going to have different overall effects than, say, in Nevada or Colorado, or let's just say a western state where you don't have a ton of commuting traffic coming in and out of a state. So yes, that could potentially be a concern for states. If you live on a border, you commute through a state and where you live doesn't offer sports betting, but the state that you drive through or that you commute to does, of course, if you wanted to sports bet, then that's a very legitimate avenue for you to do that. So yes, that is a potential issue. I think it's exacerbated by looking at certain areas of the United States, and I think the Northeast, in particular the I-95 corridor, is sort of it's ideal, if you will, or it could be it could be a potential issue for states that are operating in that particular area.
Thank you. So we have a number of other questions that have come through, and what I'm going to do is ask Ethan to reach out to those folks and answer those questions offline because we have reached the end of our webinar. Thank you so much for attending, and have a wonderful day.